All right, here we go. Hi, this is Curt,
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup. This time, we're doing it on February 4th, but it is for February 5th. Brad, go ahead. Take
All right,
us
and
away.
hopefully my internet it sends to kick me out on Zoom. So if I freeze up, look funny, I'll be back another 30 seconds later. Any event, let's start in Nebraska today. So this is kind of a continuation story. I think the real story here is, and I'm going to go through the very, very simple facts, but people have to understand that there's two parts to discrimination. There's the discrimination, and then if you retaliate against somebody for being a witness or for participating in the investigation or trial, you're gonna pay money. So here we have a Nebraska Fire Department who actually settled two gender discrimination suits, and the suit they just settled was, and we'll go through the money, was because the two people were retaliated against for reporting sexual harassment. Previously, let's go back in time, we had other suits that had previously been settled in 2020, and we had a jury verdict. And the settlement, I think, was 280,000 on one, and we had a $1.2 million jury verdict that was then reduced to 600,000. But still, that's almost $900,000 of awards basically and payments as a result of discrimination. So discriminating is not cheap. Now we have two 2022 lawsuits, and we have a settlement of 650,000 for one and 250,000 for another. And these were as a result of these individuals reporting it. So even though the city came out here and said, hey, we don't tolerate discrimination or harassment in the workplace, obviously maybe they did, right? At least according to their a jury. So that's kind of bread and butter. Anything more that we need to talk about on that?
Not really. I feel bad for the whole situation. I know I've done some work with the folks in Lincoln, the fire department. They seem dedicated to resolving any sort of claims of discrimination. The facts, and I believe you when I talked about this one. I'm just looking at, yeah, it
We did.
was
We
last
did do this before.
August,
Yeah.
where one of the females alleges that she was abandoned. She was a captain or acting captain, but she claims she was abandoned by another captain, which that it doesn't make sense to me. I don't know how one captain can abandon another captain. You're a captain, you've got your crew. He's a captain, he's got his crew. So I don't. There's a lot of things that don't make sense to me, but I think it's good that they're moving on. They get it resolved, and I don't. It's inconceivable to me that you can have this nugget of lawsuits, nugget of litigation here, without there being some sort of person with a problem. Okay. Now, whether that person is a supervisor who's creating the problems, okay, or some of the people who are victims, somewhere in the mix, when you start seeing multiple lawsuits coming out like this, and this is where I want to do my research, is really on whether or not we've got a high conflict person somewhere in the mix. And again, could be a supervisor, could be a high ranking supervisor, could be the victim. But that's really one of the things I want to focus my research on.
Yeah, it's not hard to believe, of course, that in a bigger city,
Mhm.
problems, it's not like a small department where the chief's in the firehouse all the time and puts an end to things that they hear, right? In a bigger city,
Right.
multiple stations, things
Yep.
happen, and it only takes one bad, whoever the station supervisor is at the time, captain, lieutenant, battalion chief, whatever, to not stop what's happening, and then it blows up. And meanwhile, the city's saying, listen, we don't tolerate it, which is true.
Right.
The city may not tolerate it, but in that station, it was being tolerated if it was happening by someone. Jury
Yep.
clearly agreed that it was happening. And whether the settlements were to save litigation costs, here I don't think so. These are pretty high settlements just to avoid litigation
Right.
costs.
And at some point, I think you just got to say enough is enough. This stuff goes back at least to 2018 and probably earlier than that.
Right.
So I
Bad
think
for everybody.
I think it's unfortunate. I hope that everybody can kind of move on from it. But I still am the scientist in me, right? The psychologist, the biologist, the scientist in me is intrigued by these types of cases where we see a lot of litigation, because I think that somewhere in there's a high conflict person. And one of the challenges, and again, I don't know any of the people involved in this, so I haven't spoken to any of them, so I really don't know. But I know that some of the folks that are high conflict have a tendency to alienate people. And then what happens is that offends our culture, and then there's retaliation against them. And I think that's a problem, because our supervisors aren't really well trained in how to deal with that scenario. And it's harassment. It meets the definition of harassment. And you can't rationalize harassment by saying somebody's a pain. You have to nip it in the bud. And so I think it's an interesting area. I think it's really unfortunate, but it is what it is.
Okay. We got a couple FDNY cases. Let's do them both.
Yeah. I actually find myself trying not to cover New York cases, because I don't want people to think that, but there's just so much. I passed several New York cases, pretty good cases, just because I didn't want to make it all about New York. So,
well, but look, FDNY, LA, Chicago, Detroit, I mean, they're just big, departments that you have. So big departments will have big problems. I mean, that's just how it is. Okay, but this one was not one of the FDNY's problems. You and I have talked about the special duty rule a few times. This is another great example of how we evaluate one of the factors. So let me talk about it. So here, the appellate division, the second highest court, state level court, dismissed a case or affirmed the dismissal of a case brought by a kayaker. The kayaker was in trouble. A 17-year-old was in trouble. I think the FDNY attempts a marine rescue, and the boat, I think the propeller struck the kayaker, causing serious injuries. Now, most people might say, they were negligent. Well, that's not even the proper terminology. So I want to clear this up. Negligence is a standard of care. What this lawsuit it is a unintentional tort, right? An unintentional action or omission case. But there are four elements of these tort cases, unintentional injury, unintentional conduct cases. The first is you got to prove a duty. The second, that they violated a standard of care, right? And they violated their duty by violating a standard of care. The third, that their violation caused the injury. And the fourth, that there's injury. But here, this is not a normal negligence case, because, as the court very well explains, as have many other courts, this wasn't novel or unique. I think you and I would have predicted this outcome. But when you assert a tort claim against a municipality, if they're involved in a governmental function such as firefighting or police, then the plaintiff, the person suing, has to prove not that he or she was owed a duty, but that there's a special duty, or sometimes called a special relationship. And that special relationship has four factors to prove the first element, that there's a special duty. But one of those factors, I won't go through all of them now, but one of those factors they have to prove is that the person was told, the injured victim was told to do something, and as a result of doing what they were told, like, hey, wait there, or don't go there, or stay in the house, right? Something, or don't jump, something like that. And the fire department fails to act. So it's basically, you have to say, listen, I relied on the fire department. They told me to do or not do something. I did or didn't do it. And then the fire department didn't follow through. So I got hurt as a result of that. In this case, the court says they didn't tell you to do anything. Right? They weren't put in a dangerous position as a result of the fire department. So there was no one-on-one relationship where they said, hey, do or don't do something. And that as a result of not doing what they said to do, there was none of that. I'll give you a very quick example so everyone understands it. with one of the famous cases in New York where somebody calls the police and says, help, somebody's, broke into my house. I think they're going to kill me. And the dispatcher says, stay there. Well, the police never made it to that house. So the person calling relied on the dispatcher to stay there. And as a result of staying there and the police then not showing up at the right address, the person was hurt. That's a good example of what this case lacks. They just don't have that one-on-one reliance to do or not do something that resulted in justifiable reliance, resulting in the injuries. And that's, the judge kicked it. This is what we would call a bread and butter case as well, although non-municipal attorneys may be caught with their proverbial pants down, not really understanding the special duty rule.
Yeah, no, I agree. And I was just working on an article on both the public duty doctrine, which New York doesn't use that term, but you do it, but you accept it, and the special duty rule. And I spent a lot of time in the article because I wanted folks to understand why that makes sense. Like, why doesn't a firefighter have a legal duty to render aid? Why not? And it's not just firefighters, it's government. And the real reason, separate all the other factors here, is that we could, in essence, become an insurance provider. Right. Because anything that happens to anyone, they could say, well, government didn't do enough. You should have had this law. You should have had that law. You should have had a red light instead of a stop sign. The red light should have been a minute, and then a 15-second pause, and then before it turns green. Like, there's always something else that somebody can allege that you should have done. And the solution, and it was really a judge-made solution, is to say, we don't have a duty, a legally enforceable duty to the public. That's the public duty doctrine.
To back up even one is, don't forget, or to remind the viewers, sovereign immunity, right? The state, cities, municipalities all have the protection of, at law, there's no right to sue them. Had.
And that's the funny thing. The history behind the public duty doctrine is that as sovereign immunity started going away through tort claims acts, the court started ramping up the public duty doctrine. It was an old doctrine, but they started ramping it up because otherwise we were going to be held liable for everything. Right. So yeah.
All right, so now we have this case is just funny, and I cannot believe that the attorney for this case, and I'm glad you did this because this is such a great case on simple facts, but don't lie to a court.
Did you read the decision? I mean, the decision is just,
The judge was furious, but here's what happens, right? So an former FDNY electrician was accusing the city of discriminating and retaliating against him as a result of an injury he allegedly suffered. Except, let's go back a couple years, he sued a property owner and said, the sole reason for my injuries was because I was walking along and you maintained a dangerous property. Never mentions a fire truck, never says he got out of a fire truck. And again, he said the sole reason for my injury. So now go to this one. He says, well, I was injured because I was getting out of a fire truck and I slipped. Wait a minute. That doesn't make any sense, says the judge, right? And you previously, and so you lied now because you didn't disclose the prior suit, which you're required to do in your pleadings. You normally, at least in New York, have to say, I have no other action, no other lawsuit seeking the same injuries for the same events. So I don't know whether they did that or just omitted that and no one caught it. But to say that, well, I was doing this, and that's what caused my injuries, and it, walking along, and it never mentions a fire truck. And now he's saying, well, it was a fire truck that caused the injuries. Come on. So the judge, this is in day 4 of trial, jury trial, I think. And the judge, as almost at the end of the plaintiff's presentation of their side of the suit, the judge just puts an end to it and says, stop, this is fraudulent, and dismisses the case right there and says the jury could never have found anyway what the plaintiff wanted him to, but that said, this is fraudulent. And I didn't see there that they sanctioned the attorney, but that's got to be coming if this was the same attorney who knew or should have known about the prior case.
Yeah, and you can, if they maybe had done a better job of parsing the injury as sort of one thing, and then the discrimination as a different thing, but it all got kind of mixed in there. And that again, I don't want to throw salt on the wound of the attorney, but
if he
you
knew
know,
or she knew.
yeah, it's really unfortunate. But for the legal eagles may want to read the decision, and it's it's not it's funny but not funny. It's not good for the lawyer. So.
No, no question, no question. And hopefully the client pulled one over on the attorney. You never want to see an attorney get hot water.
No, absolutely.
So we got two more to do. Let's end with the one you just posted. Let's go to this one. So we're going to go to Colorado now, but I know it's a very long case. I'm going to focus on one slight part of it because I think it's important. I think it's a very interesting issue. We're just going to have some back and forth, obviously, between Curt and I on some of the issues that may cause the lawyers problems or maybe help. But here's what we got. We have a Colorado fire lieutenant. He was terminated because allegedly, right? This is all alleged. I'm not going to say alleged 100 times. This is just a lawsuit. This is not a verdict or anything. So it's all allegedly, but he's allegedly terminated for failing to comply with requirements for his return to duty. And what happened is he had a DUI, right? So driving under the influence. So he was found or admitted or whatever to be under the influence. Now, most experts would say, well, if you drove intoxicated, you have a drinking issue. You have either an addiction or an alcohol problem. Let's say that. And I'm not one of those people. I don't know, right? But I've heard that numerous times. You can deny it all you want, but the fact is you got into a car, you're intoxicated, you have a problem. So go through all this. Basically, the employer says you have to go to rehab. Very important fact. And gives time for rehab, so we won't have a family medical leave issue. But what they required was that the lieutenant then provided proof of progress through the rehab. And even though some of it was kind of kicked back on an internal appeal from one chief, kind of overruling the prior chief, as I understand it, the allegation, and correct me if I'm wrong, the allegation's really, well, you told me I had to keep providing my medical records to you, and as a result, you're violating, the allegation says, I'm going to disagree with it, but the allegation says you're violating the ADA by requiring my medical records because it's showing I have a disability. Does that sum up the crux? Because I really want to talk about that issue.
I don't understand. There's another part of this that has to do with the fire departments being consolidated. And so he was initially disciplined under one, then it was consolidated, and we have a lot of chiefs kind of getting their hands in on this. So that it made it difficult in terms of understanding what was going on. Was my confusion.
So let's focus on the question, right? Because it's a major allegation. When somebody's in rehab, and they haven't used for a short while, one, are they protected by the ADA? The short answer to that is, in many cases, no, because although alcoholism is a disability, you are not protected under, it's not really the ADA that's the issue, it's the Rehab Act that's the issue, the Federal Rehab Act. But just because you're not using at the moment doesn't mean that you are qualified as having a disability or that, right? So what if you're using, you're not protected by anything. Anyone who's still using, start with that rule, is not protected by ADA because users are not a disability, and they're not protected by the Rehab Act, which basically says you can't punish somebody for going to get clean. Right? And there's certain questions you can and you can't ask. Here, what's happening is they want proof. The employer wants proof, which is very common, wants proof that you're completing, right? They want progress reports. Now, they didn't really go into what do they want in the progress reports. But here's the thing. It's kind of the circular reasoning. I think it gets thrown out. And frankly, I think it could get thrown out on motion to dismiss because I don't think they're protected by the ADA because they just went into and are progressing through rehab. So they may not have a disability if they're right, if they're still a user, and
could they be regarded as?
Well,
Think
no, I'm going to
he's
argue
trying to
no.
thread that needle by saying I don't have a disability, but I'm being regarded as.
Well, but they do have a disability. I think most experts are going to say, experts in alcoholism, you were driving intoxicated, right? You use poor judgment. That is clearly alcoholism. It may not be the, going to work red face type alcohol, right? Drinking under the desk, but it is definitely an addiction or a problem. So, but here the issue wasn't that they went to rehab. They didn't say, oh, we're penalizing because you went. They wanted progress reports. So are you entitled to progress reports? And I was trying to do some research on this, and I found some EEOC opinions, informal opinions, and generally speaking, you are allowed to ask for progress reports. Now, once you're clean, right? So this would be very different than saying somebody comes to you and says, listen, I'm a 3 years ago former addict, I'm in rehab. You could not then say, oh, well, I want all your medical records for, right, to see your rehab. Employers can ask for proof of a disability, right? They can ask for proof of job fitness. That's where we are in the middle. But while they're in rehab, asking that you're attending is clearly not a violation. The employer knows you're going. The employer may be paying for them to go. I wasn't sure. And so they can ask for proof that they are still there. They know there's a disability, so to speak, right? So they're not learning anything they didn't know. I think he gets dismissed. I think
I got a question for you because I read it and I was actually going to ask any of the folks out there that are attorneys that practice in this area that have a level of understanding that goes beyond what ours is whether or not in order to get access to that information, you have to have a last chance agreement, because that's the complaint actually says that. And I said, when I read it, I was like, I never heard of that. Do you have to have a
I will tell you that I don't remember, I didn't focus on it, but in 2 of the EEOC, Equal Employment Opportunity Commission opinions I read, they talk about one had, and I can send these to you, one had a last chance agreement and one is talking about the requirement of it. It seems to me to be very valid to have one, because if they don't get clean in a certain amount of time, you can say, I'm sorry, you're fired. I don't have to keep you if it takes you 3 years to get clean. I don't have to keep you for 3 years. So if you can't return by a certain date, right? And so the last chance, the way I would do it is to say, wait a minute, if you have until this date, let's say a year later to get clean, we'll keep you out, or 26 weeks if you just want to give the FMLA and they don't have vacation, or, at the end of their time, right? 26 weeks plus vacation time, you could say you have to return to duty clean with a letter that says you can fulfill the essential job requirements because you'll be sober and not intoxicated. That's certainly fine to do. But what's the failure? Well, if you don't, you're terminated. If you get caught for addiction again, you're terminated. An employer does not have to, right, tolerate constant addiction problems, especially when it's a danger to the community, like in firefighting. So I think it's appropriate to have a last chance agreement, and I think it's almost should be the case. But there are 2 opinions at least that talk about it.
It should be, but what if you don't? And I again, we've got 2 different organizations. So he's disciplined initially by one organization. Now he's consolidated into the second organization. You have questions, even if he had a last chance agreement, does a last chance agreement with the first organization bind the second? Forget all about that.
Very, very complicated.
The question is, the allegation is he was not under a last chance agreement. He was just told you've got to do A, B, and C. And now they're saying you didn't do A, B, and C. And now the complaint is alleging that in the absence of a last chance agreement, you can't get access to our medical information. And I want you to kind of draw an analogy to the way the ADA handles hiring. And you can't send somebody for a medical or a psychological until you give them a conditional offer. And that's at the hiring stage. Okay. So now we're looking at an analogous situation, but we're looking at the termination or discipline stage. Again, I knew about the conditional offer part of that at the hiring stage. I was not aware in the discipline area that you've got to have a last chance agreement. Not that it's good to have it, but that you have to have it.
I didn't see, and again, once this case came by, I was really interested, and so I was looking up, and there was a lot of discussion about last chance. I don't recall saying you had to have one as part of those.
Let's open it up, and certainly any of the folks out there that are, I mean, we don't need opinions. you know,
Right.
but if you're an attorney and you've researched the issue, you've got some case law, because I'm really surprised that he didn't put a cite in there that if that is a requirement, if I was doing the pleading,
Yeah, violation
not
of the law.
required, I would have basically cited it, because
I'm gonna
I
look.
don't
I'm
think
gonna
that,
research that tonight for you. So
yeah,
maybe we'll post something. But
yeah.
because I'm giving another disability discrimination case topic at my conference, and I saw this. I'm like, great issue. Can you require, the medical record progress? Right. That was one big question, and two, now the
Mhm.
last chance. I'm gonna find that out tonight.
Yeah.
But I think it doesn't have to have one. On the other hand, look, if somebody came, let's say you don't have one, right,
Mhm.
and let's say you don't have to have one. Somebody comes back intoxicated again.
Mhm.
It's your second offense.
Well, yeah, and that's I think that he wasn't terminated for that, though. He was terminated because he wasn't providing the updates.
Right.
And his
Right.
position is, I don't have to in the absence of a last chance agreement.
Yeah, I
So,
think that I think look at it this way. If you look under Family Medical Leave Act, right?
mhm,
I don't think they pled that, but if you look at this as an FMLA issue
right.
for its intermittent leave, it is the same rules as intermittent leave. And
Mhm.
under FMLA, we can request proof that you still have a medical condition, and we can request when can you return.
That's right.
So if you align this to FMLA leave, we certainly have the right to ask for progress reports, right? And if you can't return by a certain date, we don't have to keep you.
Yeah. I wonder if that's maybe why he didn't plead FMLA. And he may have pled it. I'd have to go through it again and look at it. But
And that's normally how people get off their 26 weeks, but some don't. So some, I'm familiar with, some places don't want to, some employees who are having addiction issues don't want to go to their employer and say, I need 26 weeks under FMLA. Why? Because you have to say basically why. You don't have to provide, total proof of it, but you have to at least say that I have this issue, right? And then they're probably going to need intermittent leave, maybe because here's when I go to rehab, or here's when I'm gone, or I'm in and out, or I go to counseling at certain times. An employer does have to let someone they have to accommodate them under the ADA by allowing them to go to rehab if it's during work, stuff like that. But you have the right to know under FMLA. You have the right to say you have to provide us proof when can you come back and that you can meet the essential job requirements. Well, if you can't meet the essential job requirements, I don't care whether you have a last chance doctrine or not. It's your last chance. So that's the problem I have. I can't imagine, but I'll eat my words later if I'm wrong because I'm going to research this very issue.
super.
Okay, last one is all you. Just
Last
posted.
one. All right. Yeah, this one I blogged about it today, and it's a challenging case here out of Portland, Oregon. But we've got an African American firefighter who feels that the promotional system is somehow being manipulated. It sort of in general, the initial complaint kind of gets into that, and the way that the city has gone around some of the merit systems. But then he gets into a couple of specific examples where he was passed over for a couple of promotions. They appear to be within the fire prevention unit. And he's alleging that white applicants for these positions were given the answers to interview questions or examination questions, whereas people of color have not. And he's seeking $1.2 million
And there
at the
was
end of the
another
day.
something. They said that he alleged, right,
Yep.
that there were two African American candidates, one or two white candidates, and they did something that would have had to the probation, that if they didn't complete probation, right, probation, you had to be off probation, but they said if they enforce that requirement for this, they would have been only left with the African American candidates, so they waived that requirement. Those two things together, if true, are very damning. They do not look
Yeah.
good.
No, absolutely. And I think one of his problems is going to be the 300-day rule with the EEOC. You've got to, when you file, when you are alleging discrimination under Title VII, you basically, from the day you file at the EEOC, you can look back 300 days. And there are some exceptions to that, but generally you can go back 300 days. Um, some of the allegations that he's made go back beyond the 300 days. So he's got an issue there.
But they can use it not as the cause of action, but they can use it as patterns of discrimination.
Exactly. If he can show a continuous, it's been a continuous practice, continuous pattern. So that's going to be one of his issues. But certainly, yeah, that last, the last promotion that he got, and also, he was apparently put into a training program, and then really kind of disturbing. They said that all of the white applicants all had their books and binders out on the table, and his was in the back facing the wall, and that
and then he got assigned a bunch of jobs to do that would interfere, I think the way I read it, interfere with his attendance.
I mean, not that it matters, not that it matters, but the fire chief is African American female in Portland, so I just like that kind of nonsense. If that's going on, I find it hard to believe that in a city like Portland, that kind of stuff is going on. If it is, he should get some sort of compensation for it. Absolutely. But I'm curious, about whether or not the facts are going to be able to be established, in court.
Yeah. And, one of the other things I like curious, that's a good, nice way for us to say, things that make us go, but one of the things that I question, look, it's one thing in a firehouse where the harassed person says, this person did this, the same person did that, the same person did this, right? But this is like a whole conspiracy. The people who interviewed are over here, the people who make decisions are over here, the people who turned my books are over here, the people who gave me all these other assignments are over here. That's a lot of people in a conspiracy. And we're not, right? Curt and I are not saying you're lying, you're not lying. We're not saying that. But one of the things that make you go, are how many people are involved in this series of allegedly racist acts, right?
Yeah.
That's where I had. That's a lot. This is not like one person, one firehouse keep doing the same thing. That's a tough.
The term progressive. When I think of the term progressive, Portland is one of the cities that I think of.
Yeah.
And for this to allegedly be going on, not that it could be, it could be, but
it just takes a lot of people. It takes a systemic, institutionalized racism that is so widespread that the whole institution would almost be corrupt, unless the same people happened. But it wasn't the same people. It had to be different people doing all these different things.
Yeah.
So yeah,
we'll see. I mean, just like a lot of the cases, we'll see. And if the proof is there, then he should prevail.
Agree. That is us for our Sunday,
right.
Monday.
That's it. And I apologize for us getting out ahead of this, getting it done on Sunday. I'm headed to Austin, or actually Georgetown, Texas, for our FLSA class that we're going to be doing this week. But we should be back on track for next week, unless you're traveling next week. So
no, I am going to have a jury trial in about 4 weeks. That'll take me out for maybe 2 weeks, but we'll talk about it as we get closer. I have some really neat stuff to send to the blog soon. Just waiting to see. And
settlement, maybe.
Yeah, and maybe, and one of it's going to be on how sleazy are some lawyers. Let me tell you, I'm gonna shed some light on some sleazy lawyers.
I've got scars on my back too, so trust me. So,
all right, very good.
All right. Well, that's going to do it